Responding to a trademark refusal. Sometimes your trademark will receive at first an initial refusal. We call this an office action or provisional refusal. This is issued ex officio. In Latin, it means that it's on the office's own initiative to find certain deficiencies with your application. Office actions come from an examiner at the trademark office. They review your trademark application for formal and informal requirements. They often issue a refusal that you will have to respond to, and there are many reasons that you can get an initial refusal. Some reasons are easy to resolve, and they can even be resolved by a phone call. But when it is a refusal that is something substantive, you'll need to respond with a legal argument or hire an attorney. As far as the easy issues are concerned, these are things like translating a foreign word, describing a logo, or disclaiming a descriptive word in the mark. However, you may also receive a substantive rejection, and in such an event, you can certainly attempt to make your own legal arguments. But usually this is when hiring a good trademark attorney may be worth the expense. Let's talk more about these substantive rejections. When the trademark office refuses your trademark based on relative grounds of refusal, the most common substantive reasons will be based on likelihood of confusion. The examining attorney believes that the mark you applied for is likely to be confused with another earlier trademark application or registration. The office is not always correct in making this assumption, but in order to convince them that there is no likelihood of confusion, you'll have to submit arguments in the form of a written brief. In some trademark offices, there's an online form to submitting your arguments, but you still have to write something intelligent in order to convince the examiner that the mark is not likely to be confused with the prior mark that the examiner has cited. You can also hire an attorney at this point and let them do what they are trained to do. The most common refusal ex officio is based on absolute grounds of refusal and consists of the examiner's belief that your trademark is descriptive. As we've discussed, in order for a trademark to be registered, it must be distinctive. If it appears to describe the goods or services in the application, then it will be considered descriptive and it will initially be refused. Let's say that your brand is Crazy Clippers for a barbershop. If an examiner claimed that this was descriptive, there would be a good argument that it is not descriptive. I mean, after all, are all the barbers crazy at Crazy Clippers? Probably not, as the name is not describing a place where all the clippers are crazy, but rather presenting a whimsical way of suggesting a place where the barbers might create a new hairstyle or edgy modern haircuts. In that case, you would want to argue with the examining attorney as such and make your case in a creative way. Simply remember, just because you have a refusal does not mean that the examiner is right. Many times you can make a good argument without the help of an attorney and try to persuade the examiner in your favor, provided that you know the law and understand the argument the examiner is making. If you receive any type of refusal, you will need to file a response within the strict deadline given to you by the office. Now, if you fail to respond on time, your application will be deemed as abandoned and discontinued. Normally, these deadlines are not extendable except when you're dealing with the European Community trademarks and certain other jurisdictions as well. Once you've made your arguments to the examining attorney, he will respond to you in time. The outcome is often an approval, in which case the mark moves along to the next step in publication. In some cases, you'll get a final refusal, and if you do receive a final refusal, you can appeal in certain jurisdictions. Now, let's assume that the examiner agrees with you and withdraws his refusal. You'll then move along to the next step in the registration process. Once approved, all applications are published for 30 to 90 days, and during that time, third parties can oppose your application. If no one opposes you, well, then your trademark application can advance to registration. Please feel free to watch more of our videos to get valuable insights about the mechanics of applying for trademark registrations, defending your marks, opposing other conflicting marks, dealing with office actions, and many other intellectual property issues. My name is Jonathan Morton, and I am a licensed U.S. attorney and a member of the Trademarkers Network. Don't forget to subscribe.